A pleasant day to everyone who is listening. So, today I will be reporting on the emergence of digital evidence, forensic processing, and its applicability. Digital evidence, also known as electronic evidence, is defined as the information stored or transmitted in binary form that may be relied on in court. It can be found on a computer hard drive, a mobile phone, among other places. Digital evidence is commonly associated with electronic crime or e-crime such as child pornography or credit card fraud. It is also defined as the information and data of value to an investigation that is stored on, received, or transmitted by an electronic device, according to the National Institute of Justice. So, our topic for today would revolve around the forensic discipline of digital forensics. So, digital forensics has a great potential and capability to prove the guilt of offenders committing modern crimes or even ordinary crimes. With today's present situation, the rampant abuses committed online or the cybercrimes, violations against data privacy, or violations against the Anti-Photo and Video Voyeurism Act or the Republic Act number 9995, child pornography, credit card fraud, dark web, darknet markets, or the online black markets that sell illegal drugs, firearms, malware, pornographic materials, and even the commission of terrorism. The battle should be equated with reliable and credible proof through the science of digital forensics. In the ongoing technological advancements, there have been increased concerns regarding the computer crimes or cyber crimes. In this case, computer crimes have the institutional, legal, and technical challenges that are far reaching. Forensic science should not be only limited to biological evidence or the traditional forensic disciplines, but it should also be with digital or electronic evidence or our modern technology. This forensic discipline could be most suitable in terms of electronic or e-crimes. Porter in 2018 noted that the offenders use trends and keywords in connection with their criminal activities and their techniques, and that the respondents become more cautious with their actions as the law enforcement take the steps to brawl with these modern crimes. So we have our digital evidence to help us, to help the law enforcement fight these modern crimes. And digital evidence, it is also defined as the volatile and fragile and the improper handling of this evidence can alter it. Because of its volatility and fragility, protocols need to be followed to ensure that the data is not modified during its handling. Example, during its process, collection, packaging, transfer, and storage. There are protocols for collecting volatile evidence. Volatile evidence should be collected based on their volatility. That is, the most volatile evidence should be collected first and the least volatile should be collected last. The request for comments document provides the following sample of the order of volatile data and standard systems. So let's go to the protocol for collecting volatile digital evidence. The following would be the order of the collection of digital evidence according to its volatility and fragility. So, first to be collected would be registers or cache, routing table, cache process table, kernel statistics, memory. Next, we will collect temporary file items, disk, remote logging and monitoring data that is relevant to the system in question, physical configuration, network topology, and our archival media. So the following could be the sources of our data. It could be social networks, big data, backup server, cloud storage, legacy systems, and group shares. Now let's go to the phases involved in the initial handling of evidence or the forensic evidence. First would be the identification. In the identification phase, preliminary information is obtained about the cybercrime case prior to collecting digital evidence. This primary information is similar to that which is sought during the traditional criminal investigation. The investigator seeks to answer the following questions. First, who was involved? Next, what happened? When did the cybercrime occur? Where did the cybercrime occur? And how did the cybercrime occur? The answers to these questions will provide investigators with guidance on how to proceed with the case. For example, the answer to the question, where did this crime occur? That is within or outside the country's borders. That will form the investigator on how to proceed with the case. In the identification phase, cybercrime investigators use many traditional investigative techniques, especially with respect to the information and evidence gathering. For example, victims, witnesses, and suspects of a cybercrime are interviewed to gather information and evidence of the cybercrime under investigation. For example, those adults or children who witness, based it should be based on the law. Of course, the actions should always be based on the law. And undercover law enforcement investigations have also been conducted to identify, investigate, and prosecute cyber criminals. Additionally, cybercrime investigators have conducted covert surveillance. This tactic is particularly intrusive method for collecting evidence. The use of covert surveillance measures involves a careful balancing of a suspect's right to privacy against the need to investigate serious criminality. Provisions on covert surveillance should fully respect the rights of the suspect. There have been various decisions on international human rights bodies and courts on the permissibility of covert surveillance and the parameters of these measures. Even malware has been used by law enforcement agencies to conduct surveillance in order to gather information about the evidence of cybercrime. For example, U.S. law enforcement agencies are using network investigation techniques, especially designed exploits or malware, in their investigation of online child sexual exploitation and abuse. Before the digital collection begins, the investigator must define the types of evidence sought. Digital evidence can be found on digital devices such as computers, external hard drives, flash drives, routers, smartphones, tablets, cameras, smart televisions, internet-enabled home appliances such as refrigerators and washing machines, and gaming consoles as well as public resources. For example, social media platforms, website, and discussion forums. And private resources, internet service providers, logs of users' activity, communication service providers, business records, and cloud storage providers records of user activity and content. Many applications, websites, and digital devices utilize the cloud storage services. Users' data thus can be restored wholly or in fragments by any different providers in servers in multiple locations. Because of this, retrieving data from these providers is challenging. The evidence sought will depend on the cybercrime under investigation. If the cybercrime under investigation is identity related fraud, then digital devices that are seized will be searched for evidence of this crime. Next, we have the next phase would be our collection. So for collection, with respect to crime scene, the crime scene is not limited to the physical location of digital devices used in the commissions of the cybercrime and or that were the target of cybercrime. The cybercrime crime scene also includes the digital devices that potentially hold digital evidence and spans multiple digital devices, systems, and servers. The crime scene is secured when a cybercrime is observed, reported, and or suspected. The first responder identifies and protects the crime scene from contamination and preserves volatile evidence by isolating the users of all digital devices found at the crime scene. The users must not be given the opportunity to further operate the digital devices. Neither should the first responder nor the investigator seek the assistance of any user during the search and documentation process. The investigator is different from the first responder, searches the crime scene and identifies the evidence before the evidence is collected and the crime scene is documented. So for documentation, it is needed throughout the entire investigative process. This documentation should include uh, detailed information about the digital devices collected, including the operational state of the device, on, off, standby mode, and its physical characteristics, such as make, model, serial number, connections, and any markings or any damage. In addition to written notes, sketches, photographs, and or video recordings of the crime scene and evidence are also needed to document the crime scene and evidence. In collecting volatile evidence or data, it can alter the memory content of digital devices and data within them. So the investigator or the crime scene technician collects the evidence. The collection procedures vary depending on the type of evidence. And public and private resources for digital evidence resides, such as computers, phones, social media, and cloud. Digital forensics or different practices pertaining to multimedia, video, mobile, uh, That's what will happen then. That's what we could collect on the cybercrime crime scene. So, a standard operating procedure is designed to assist investigators by including the policies and sequential acts that should be followed to investigate a cybercrime in a manner that ensures the admissibility of collected evidence in a court of law, as well as the tools and other resources regarding the conduct of the investigation. Overall, SOPs include the processes to be followed during the investigation. So we also have operating procedure, which is done during the investigation of our cybercrimes. So, unique constraints that could be encountered during the investigations could be also identified. For instance, cybercrime investigators could encounter multiple digital devices, operating systems, and complex network configurations, which will require specialized knowledge, variations in collection procedures, and assistance in identifying connections between systems and devices. We have anti-forensics techniques. These techniques such as steganography. So, for example, the healthy or the stealthy concealment of data by both hiding content and making it invisible, and the encryption, physically blocking of third party to access a file, either by using a password or by rendering the file or aspects of the file unusable. So it could be encountered during investigation. So these types of countermeasures that is done by the offender or the perpetrator could be a hindrance or could be the constraints that our investigators might face during the conduct of the investigation. So, because of this, the investigator should be prepared for these situations and have the necessary human and technical resources needed to deal with these constraints. So these constraints really make the investigation challenging. So the actual collection of evidence involves the preservation of volatile evidence and powering down of digital devices. The state of operation of the digital devices encountered will dictate the collection procedures. For instance, if a computer encountered is or if the device is on, volatile evidence is preserved before powering down the device and collecting it. If the device is off, then it remains off and is collected there. There are circumstances where digital devices will not and cannot be collected, and their complexity or because of this situation or because of the complexity of their hardware and software configurations, it will not make us be able to collect these digital evidences. So, in these situations, volatile and non-volatile data are collected through special procedures that require live acquisition. The type of digital evidence or device encountered during an investigation will also indicate the manner in which the digital evidence is collected. So we have trivia. Commands can be used to obtain volatile data from live systems. For example, Windows operating systems, the command or IP configuration is used to obtain network information. Whereas for Unix operating systems, the command if configuration or if config is used. For both Windows and Unix, the command .stat is used to obtain information about active connections. In addition, digital devices or other relevant items such as notebooks that might include passwords or other information about online credentials, telephones, fax machines, printers, or routers should be collected as well. So those should be also collected during the collection process, not only the volatile data, but also notebooks or other credentials, telephones, or printers should also be collected. The actions taken by the investigator during the collection of evidence should be documented. Each device should be labeled along with its connecting cables and power cords, packaged and transported back to a digital forensics laboratory. Once the items are transported to the laboratory, they are inventoried, recorded, and secured in a locked room away from extreme temperatures, humidity, dust, and other possible contaminants. So we will now go to the digital forensic tools. We have Forensic Toolkit or FTK by Access Data. We have the Volatile Framework and X-ray Forensics. So these tools could be utilized by the investigator or the forensic examiners. We also have the Faraday bag, which blocks wireless signals to and from the digital device, and a power bank are needed and used to transport them among other items. So this would be helpful in our collection phase. So these tools or kits could be helpful, or they could aid us to properly collect our digital evidence. Now let's go to the collection procedures. We have acquisition or the seizure of digital evidence. At the forensic laboratory, digital evidence should be acquired in a manner that preserves the integrity of the evidence. So we also have different approaches to perform acquisitions. The approach taken depends on the type of digital evidence. For example, the procedure for acquiring evidence from a computer hard drive is different from the procedure obtained or required to obtain digital evidence from mobile devices such as smartphones. Unless live acquisition is performed, evidence is extracted from the seized digital devices at the forensic laboratory. So to achieve this, or to achieve the forensic manner of preserving or acquisition of our evidence, the tools and techniques used to acquire digital evidence must be prevented or must prevent alterations to the data, or when this is not possible, at the very least, minimize them. So the tools and techniques used should also be valid and reliable. The limitations of these tools and techniques should be identified and considered before their use. And the U.S. National Institute of Standards and Technology has searchable digital forensics tools database with tools with various functionalities. The seized digital devices are considered as the primary source of evidence. The digital forensic analyst does not require the data from the primary source. Instead, a duplicate is made of the contents of that device. and the analyst would work on those copies. So they will not work directly on on the data. Instead, they will work, or the forensic analyst would work on the copy of the data, or the data that were collected during the collection process. This duplicate copy of the content of the digital device is created before a static acquisition is conducted to maintain the integrity of the digital evidence. To verify whether the duplicate is an exact copy of the original, a cryptographic hash value is calculated for the original and duplicate using mathematical computations. If they match, the copy's contents are a mirror image of the original content. A write blocker, which is designed to prevent the alteration of data during the copying process, should be used before extraction whenever possible in order to prevent the modification of data during the copying process. It is important to note that the acquisition process described above mainly or applies mainly to computers. When acquiring data from mobile phones and similar devices, where the memory storage can be physically separated from the device, to make an image, a different procedure is followed. So we have two types of extraction. First, we have the physical, and next, we have the logical. For the physical extraction, it involves the search for and acquisition of evidence from the location within a digital evidence or device where the evidence resides, such as the hard drive of a computer. A physical extraction may be conducted using keyword searches based on terms provided by the investigator, file carving, for example, searching the base header and footer and other identifiers, and by examining an allocated space, for example, a space available on a system because it was never used or because the information in it was deleted, and partitions, which separate segments of the hard drive from each other. So, for our logical extraction, it involves the search for and acquisition of evidence from the location it resides relative of a computer operating system, which is used to keep track of the names and locations of files that are stored on a storage medium such as hard disk. This type, or the type of logical extraction conducted, depends on the digital device, file system, and applications on the device and operating system. So, a type or a logical extraction involves the acquisition of data from active and deleted files, file systems, unallocated and unused space, and compressed, encrypted, and password protected data. And it should also be noted that the entire acquisition process should be documented. This documentation should include detailed information about the digital devices from which evidence was extracted, the hardware and software used to acquire the evidence the manner in which the evidence was acquired, when it was obtained, where it was obtained, why it was obtained, what evidence was obtained, and for what reason it was obtained. That is all for our acquisition. So that is part of our collection process. Now let's go to preservation. So for preservation, evidence preservation seeks to protect digital evidence from modification. The integrity of digital evidence should be maintained in each phase of the handling of digital evidence. First responders, investigators, crime scene technicians, and/or digital forensic experts must demonstrate, wherever possible, that the digital evidence was not modified during the identification, collection, and acquisition phase. The ability to do so, of course, depends on the digital evidence. For example, computer and mobile phones, and circumstances encountered by them need to quickly preserve data. So we have, of course, we should always maintain the chain of custody. So the chain of custody is the process by which investigators preserve the crime or incident scene and evidence throughout the life cycle of a case. It includes information about who collected the evidence, where and how the evidence was collected, which individuals took possession of the evidence, and when they took possession of it. In the chain of custody, the names, titles, and contact information of the individuals who identified, collected, and acquired the evidence should be documented, as well as any other individuals. The evidence was transferred, details about the evidence that was transferred, the time and date of transfer, and the purpose of transfer. So that is for our chain of custody. It should always be maintained so that we can ensure that our actions are documented and it will not, or our actions will not be questioned by the court, and the evidence that we have collected will be admissible in court. So that is a very important aspect, not only in the aspect of digital forensics. It is also important in all of our case. So now let's go to analysis and reporting. So in addition to the handling of digital evidence, the digital forensics process also involves the examination and interpretation of digital evidence, or the analysis phase, and communication of the findings of the analysis, or the reporting phase. During the analysis phase, digital evidence is extracted from the device. Data is analyzed and events are reconstructed. Before the analysis of the digital evidence, the digital forensics analyst in the laboratory must be informed of the objectives of the search and provided with some background knowledge of the case and any other information that was obtained during the investigation that can assist the forensics analyst in this phase. Various forms of analysis are performed depending on the type of the digital evidence sought, such as network, file system, application, and video or imaging analysis or media analysis. So files are analyzed to determine their origin and when and where the data was created, modified, accessed, downloaded, or uploaded, and the potential connection of these files on storage devices. For example, remote storage such as cloud-based storage. The type of digital evidence sought depends on the crime scene. So it really depends on the cybercrime case. So let's go to the forensic examination of our evidence or our digital evidence. For digital forensics is a cybersecurity domain that extracts and investigates digital evidence involved in cybercrime. So our digital forensic processes or forensic examination includes the computer forensics. We also have network forensics, mobile devices forensics, digital image forensics, digital video or audio forensics, and memory forensics. For computer forensics, it is the identification, preservation, collection, analysis, and reporting on evidence found on computers, laptops, and storage media in support of investigations on legal proceedings. For network forensics, it is the monitoring, capture, storing, and analysis of network activities or events in order to discover the source of security attacks, intrusions on other problem incidents such as worms, virus or malware attacks, abnormal network traffic, and security breaches. For mobile devices forensics, it is the recovery of electronic device from mobile phones, smartphones, SIM cards, PDAs, GPS devices, tablets, and game consoles. Next, we have the digital image forensics. For digital image forensics, it is the extraction and analysis of digitally acquired photographic images to validate their authenticity by recovering the metadata of the image file to ascertain its history. For digital image or for the digital video or audio forensics, the collection, analysis, and evaluation of sound and video recordings. The science is the establishment of authenticity as to whether a recording is original and whether it has been tampered with either maliciously or accidentally. And lastly, we have the memory forensics. It is the recovery of evidence from the RAM of a running computer, also called live acquisition. So those were our forensic examinations or of our digital evidence. So these examinations are done to proceed with our digital forensics. Now let's go to the cases solved. Before we go to the cases, let's first go to the forensic results. Of course, after the forensic examination, there should be forensic results. So, forensic science has historically produced the results that have been judged to be both valid and reliable. For example, DNA analysis attempts to develop specific identifying information relative to an individual. To support their conclusions, forensic DNA scientists have gathered extensive statistical data on the DNA profiles from which they base their conclusions. Computer forensic science, by comparison, extracts and produces information, and the purpose of computer examination is to find information related to the case. To support the results of computer forensic examination, the procedures needed to ensure that the only information exists on the computer storage media, unaltered by the examination process. Unlike forensic DNA analysis or any other forensic disciplines or our traditional forensic disciplines, computer forensic science makes no interpretative statement as to the accuracy, reliability, or discriminating power of the actual data or information. So those would be for our forensic examination results. Now let's proceed to types of analysis. So we have the time frame analysis, ownership and possession analysis, application and file analysis, and data hiding analysis. So the time frame analysis seeks to create a timeline or time sequence of actions using timestamps that led to an event or to determine the time and date a user performed some action. This analysis is performed to attribute a crime to a perpetrator or at the very least attribute an act that led to a crime to particular individual. There are, however, challenges in validating time frame analysis results. And we also have the ownership and possession analysis that is used to determine the person who created, accessed, and or modified files on a computer system. For instance, this analysis may reveal an image of child sexual abuse material, such as the representation by whatever means of a child engaged in real or stipulated or simulated explicit sexual activities or representation of the sexual parts of a child for primarily sexual purposes. So, on suspect's device. So, this could be found on the device of a suspect. So, this could reveal the identity of the person. This piece of information alone is not enough to prove the ownership of child sexual abuse material. Further evidence is needed to prove this, such as exclusive use of computer where the material was found. Next, we have the application and file analysis. It is performed to examine applications and files on a computer system to determine the perpetrator's knowledge of and intent and capabilities to commit a cybercrime. For example, the labeling or the name of the file may indicate the contents of the file. The file name can be the cybercrime victim's name. Lastly, we have the data hiding analysis. It can also be performed. So, as the name implies, data hiding analysis searches for hidden data on a system. Criminals use several data hiding techniques to conceal their illicit activities and identifying information, such as using encryption, changing file extensions, and hiding partitions. During the analysis phase, the investigator needs to address the data hiding techniques that perpetrators could have used to conceal their identities and activities. So, hidden data can reveal knowledge of a crime, ownership of a content, or intent to commit a crime. So now, let's go to the cases solved through the power of digital forensics. So we have 3 cases, but there are still a lot of cases that were solved. However, I have chosen these 3 cases. And for Matt B. Baker versus the state of Texas. So this is how would the story go. In January 2010, 4 years after the wife of Matt Baker was found dead after an apparent overdose, a 38-year-old Matt Baker, an ex-pastor from Texas, was convicted of murder and sentenced to 65 years in prison. The evidence which eventually secured Mr. Baker's conviction included data recovered from a laptop hard drive released by his church, and the main computer server at a youth center where he also served. Computer forensic analysis was able to reveal that Mr. Baker had entered the term overdose on sleeping pills into a search engine and viewed several pharmaceutical websites prior to his wife's death. So, because of those terms that Mr. Baker searched on the computer, uh, he was convicted of the crime, or he has been accountable for the death of his wife. So that's how this case was solved through the computer forensic analysis of the recovered laptop hard drive and the main computer server in a youth center where Mr. Baker served. So that is the story of Matt D. Baker versus the state of Texas. Now let's move to the next case. Regina versus Cranmer Lucia. So Cranmer Lucia of the United Kingdom was arrested based on his internet search pattern. On investigating his laptop, it was found that he had downloaded a manual of 4300 GM or 4300 GM to make explosives and search belts. When they searched his apartment for further investigation, the police also recovered 71.881 of petrol, potassium nitrate, and a live shotgun cartridge. He had also used his laptop to chat with people via MSN, describing himself as a terrorist or a sniper. He presented himself as a person who wanted to see Jewish and American people killed. These conversations were retrieved from his computer and used as digital evidence in court. So, Cranmer Lucia, his crime is terrorism. So, we had forensic digital evidence used against him to convict him in court. So, our previous case was Matt D. Baker's case, and his case is an ordinary crime or a heinous crime that we usually encounter. However, through the power of digital forensics, we were able to convict him. Now we have a terrorism case, which is not very usual, or it does not usually happen. Because these cases are considered as special cases, and forensic digital evidence had been helpful to convict this terrorist. Now let's go to our last case, Larry J. Thomas versus the state of Indiana. So in his case, more than 250 Facebook posts are mentioned as a source of digital information gathered during a forensic investigation in the Indiana Appellate Court. One of the recorded cases talks about Larry J. Thomas, who was wrongly representing himself under the name Slotaboy Laro. So, he has a different name on his Facebook account. He posted a photo on his Facebook wall with an AR-15 style assault rifle. When the investigation on the murder of Rito Llamas Juarez occurred, Larry was found guilty as Llamas Juarez was shot dead with AR-15 style ammunition. Investigators also found a bracelet near the crime scene which matched the one that Thomas was found wearing in one of the photos on Facebook. So that is the power of investigating even the social media platforms, because they could give us clues on what happens, or on that person. If it matched, there is a big possibility that this is the person that we are looking for. So for our conclusion, digital forensics provides a formal approach to dealing with investigations and evidence with special consideration of the legal aspects of this process. So the main distinction between forensics and incident response is that forensics is evidence centric and typically more closely associated with crimes, while incident response is more dedicated to identifying, containing, and recovering from security incidents. Cases become easier to solve through the aid of digital forensics. Even those who had been cold cases for a very long time see a ray of hope through digital forensics. It can be utilized not only for electronic crimes but also for other types of crimes. I have mentioned earlier our different cases that involve, uh, for example, the terrorism in Lucia's case, and the typical case of or the murder case in Matt D. Baker's case, and our last case for Larry J. Thomas, in which he killed or shot a person dead, and through Facebook, a social media platform, the investigators were able to look for this suspect. So it is uh, it really helps our law enforcement. So digital forensics is really helpful, especially today that our technology has a great advancement. Now let's go to our recommendation. So after a thorough research on the broad field of digital forensics, I came up with the following recommendations. So first, digital forensics should be given attention because it has a great potential and ability to suppress e-crimes or cybercrimes and even other types of crimes or even ordinary crimes. Thorough research should be done to explore the extensiveness of digital forensics. Digital forensics should be in line with the advancement of technology. So we should develop more. We should study more digital forensics, and as the technology advances, of course, the level of digital forensics should also uh, go forward or move forward with the advancement of technology. It should not be left behind. So that is for our digital forensics. That would be our discussion for digital forensics. I hope that we have learned a lot with this discussion. Thank you very much for listening, and God bless.